Items for pronouncement of judgment. Item number 50, RSA 101 of 2016. Item number 51, WPC 466 of 2020. Item 52, WPC 5498 of 2021.
And be clear.
53, WPC 5544 of 2023. Vote. Item 54, CRPIO 366 of 2025. '55, CRPIO 445 of 2025. I just 56, CRPIO 14 of 2026. '57, RSA 40 of 2026. '58, RSA 43 of 2026.
Next.
Any mention?
Wait, I beg to mention for listing contempt case on part heart matter mila. It was fixed but not listed. Next 8 on 8. Yes, ma'am. Obliged.
With the consent of the petitioner, I like to mention this is matter, my lord, item 1 to 5, my lord. Now, let it be taken up on 4th of June, my lord. My friend is there.
Lordship, otherwise no objection, but on 10/6, but Lordship, on 25 to 2026, a submission was made on behalf of the Advocate General that they are going to file an additional affidavit in terms of the order dated 10/6/2019, your Lordship. Till that, the additional affidavit is not
We
filed.
have filed an additional by the education department. We will not file any
The
additional.
Lordship, this may be taken, this may be
Oh.
taken on record, your Lordship, and Lordship may fix it on foot.
No affidavit will come, my lord, education department, no file.
Lordship, yes, that no affidavit is going to be filed.
No, lordship will keep it on 4th, my lord. If required, we will file it, but let it be on 4th. If required, we will go through it, and if required, we will file it before. For the response number, my lord, as for SSA, my lord. Fourth of June, my lord. Obliged, lord.
May please, your lordship. Lordship, I am praying for listing of three similar matter, lordship, land acquisition appeal, lordship, in the order.
Senior bench. Bench one matter, in the court number 3.
alia appeal.
And then,
Yes. No, lordship. Orders matter, lordship.
bench one matter. Bench one, court number 3.
Obliged.
May I please, Lordship, we are for listing a MAC appeal, Lordship. Any date, Lordship, because it's a long pending matter. I am just preparing for a date only, Lordship. 2016 incident was happened. Thereafter, in 2021, this appeal was filed, Lordship.
On 21st June, Sunday,
Give me a date. I am not suggesting any date.
on 25th June,
25th, in second week of June, Lordship, if possible.
on 18th June.
Lordship.
Yes, may I please, your Lordship, for item number 10, I have filed a wakalatnama today. So, your Lordship, kindly list the matter. Response number 5. Yes. Your Lordship, kindly court may direct to appellant serve the copies. Yes. Yes. OIA Sarkar. Fifteen of June. Yes. Please.
May I please, your lordship? I pray for listing of an IA that has been filed in an MAC appeal for orders, your lordship. Your lordship, if convenient, it can be listed on 29th of this week. 29th. Bless you.
May please, your lordship, with the consent of other side, I beg to mention item number 46 to 49 for adjournment, lordship. You Bihani. Appealant. Yes. Lordship, may fix the matter after vacation.
Hearing matter.
Vacation, summer vacation, lordship.
On 16th,
Lordship, on behalf of the respondent, sorry. Too much.
on 16th,
Sorry? Yes, lordship. Yes, Lordship, I have informed the other side.
16th July.
Much obliged.
Items for orders, item 17.
May it please your lordship. Service upon respondent number 1 and 1 to 3 is already complete, lordship. And regarding respondent 4, we have filed our paper publication affidavit also. Yes, lordship. Three, 1 to 3. Four, we have filed our affidavit. Lordship. Yes, your lordship. This I is for stay, lordship.
The month of July. 18 June
18 June.
on 11th June.
11 June. Obliged.
Item number 18 and 19.
Lordship, in item number 18, I'm for the appellant and regard services. We have to take first steps upon respondent number 2 and 3, lordship. 18. Yes, lordship.
Respondent claimant number 1. Yes, Bulu. 1, lordship.
Two and 3. Lordship, we will take first steps. Obliged.
Regarding item number 9, I have to take step upon the respondent number 2, lordship.
19.
Item number 19, lordship. 19.
Reading diary to this.
Yes, lordship. Same respondent. Yes.
Lordship, I'm for 4.
Regarding, let's say, probably regarding number Respondent number 3, his name was strike out. Let's say. So I have to take step on respondent number 2. No, let's see, his name may be strike out. Let's say. His driver. Strike out.
Item 20. Item 21.
May please, my lord. My lord, this IA is, my lord, for condonation of delay of 210 days, my lord, in preparing regular first appeal, my lord.
Lordship may kindly grant us some time to file an objection.
But main problem is that, my lord,
For respondent number 1, your Lordship.
service is complete, my lord. 2 also appeared. Complete, my lord. My lord, problem is that the
J. Sharma. 1.
complete, my lord, because I have checked in the cause list, my lord, shown the name of the respondent number 2. D. Gogol Sam. Respondent number 2 is the husband of the applicant, my lord. Husband of the applicant, my lord.
Lordship. Yes, Lordship. Lordship, 2 weeks time.
My lord, the problem is that execution is, my lord, going on, my lord. So
Lordship,
read
3/7, your Lordship. 3/7, 3rd of July.
read has already been issued, my lord. That's it. Alia.
Obliged, Lordship.
22.
May it please, your Lordship. Lordship, I'm appearing for respondent number 1. Obliged, Lordship.
23.
May I please, your Lordship, I'm appearing for respondent number 1, 2, 3, and 4. 2, 3, and 4. M. Gazlu. M. Gazlu. Gazlu. Obvious, your lordship.
Item 24. Twenty-five and 26 by VC mode. Items 25 and 26. Twenty-five and 26, Mr. Jai Hussain, please respond. Item 25 and 26, Mr. Jad Hussain, please. You are mute, please unmute yourself.
Lordship, my item was, I think, item number 15, Lordship, Rasna Ara Begum. MSc appeal, Lordship, Rasna Ara Begum. Lordship,
Okay. No, this is the different item.
Lordship, my item was item number 15, Lordship. I
Not
could not
20,
get it.
this is item number 25 and 26.
Lordship, maybe my item was 15, so I was with.
Item 27.
Let's see, resetting maybe password for the time being, let's see. I mean, because the company's officer is coming, let's see.
Earlier,
He is
they registered before Lok Adalat, my lord, and at that time, their settlement is going on. The officer is coming. Earlier order is there, my lord.
Okay, after some time.
Yes, boss.
Wait, please, your lordship. Your lordship, TCR has been received. Kindly fix the matter for hearing.
Hearing. Heard this one?
A Dev.
Learned counsel for the appellant and Miss.
P. Rabha on behalf of Miss A. Guy, correspondent
Learned
1, 2,
counsel
3.
appearing on behalf of Miss A. Gaya.
A. Guy, lordship.
Learned counsel for the respondent.
Correspondent 1, 2, and 3.
Respondent number 123. The learned counsel for the appellant submits that service in this matter has already been completed and the record has been listed, and as such, the matter may be listed for hearing. Accordingly, it is provided that your assistant is the matter for hearing after 2 weeks.
Your lordship, any fixed date?
25th June.
Much of that.
29.
Your lordship, in this matter, the TCR has been received, R2 has been served, but R1 could not be served since it was not raised. So, your lordship, in the delay condonation petition also, we took steps twice, but the third time, since it could not be served, we took steps by substituted manner, paper publication. Your lordship, we may be allowed to take paper publication on R1.
R1,
Yes, your lordship.
part is Yami, learned counsel for the appellant. Learned counsel for the appellant submits that statement is allowed to check. Allowed to check service of the respondent number 1 by substituted mode certificate paper publication. They are allowed. This is at least a matter of fact. 4 weeks.
4 weeks.
And after paper publication, the appellant said file an affidavit to that effect before this court enclosing the relevant papers. Which shall be published in 2 daily newspapers, one in vernacular and another and the other in English. Please the matter of the first. How many respondents are here?
Your Lordship, 2. Only 2. Respondent 2 is served and 1 is not served.
Notice upon respondent number 2, served. Where?
Your Lordship, as per office note dated 21/5/2026, notice has been served on respondent number 2.
Office note dated 21/5/2026 indicates that notice upon respondent number 1, no, respondent number 2. Respondent number 2 has already been served. This is the matter of purpose.
Your Lordship, a date may be given for the paper. After 4 weeks, the date of appearance.
No.
Then after 4 weeks, a date after 4 weeks,
Paper publication date will be deferred.
July. Okay. Much obliged, Your Lordship.
I'm sorry, my lord, I have missed item number 20, my lord.
Take a date from
20.
May it please your lordship, as per office note dated 21/5/2026, with service report upon respondent number 2, lordship.
Art Miss,
Mr. S. Ahmed on the behalf of Ms. R. Chaudhary.
Current Council, appearing on behalf of Ms. Office note dated 1st of May 2026 indicates that notice upon respondent number 2. Go issue. By usual process and also by speed post. Has not yet been received. No report has been received till date. And the said office note also indicates that postal consignment track report in respect of the notice issued to the respondent number 1 and it indicates that the same way. Sir. And a report to that effect has been classified positively. And the said report indicates that the items have been delivered to both respondent number 1 and 3. This the matter after 2 weeks awaiting service report upon respondent number 2.
Obliged lordship.
I'm sorry, Lordship, in item 24, I couldn't reach the code. I'm really sorry.
Yeah, perhaps we have already given the date. collection date.
But Lordship, non-APS for appellant has come.
We will record your date.
Highly obliged.
I'm the respondent number one related to item number 24, my lord.
Okay.
No, one problem is that, my lord, in this case, my lord, honorable court has directed to pay the 50% of amount, my lord, within 6 weeks, my lord. 6 is already over, my lord, they have not paid the.
No, Lordship, I have sent
Whatever.
with the order, I have sent my opinion long back. So I do not know from where he's saying that. I have sent my. No, company নিজে দিয়ে আমি check নিদিও আমি জমা নকৰো we do not deposit, Lordship, company does it directly, so for my part I have sent my opinion in item 24.
Okay, on next date we will consider
Yes,
after
yes,
2 weeks.
Lordship.
After 2
That's
weeks.
the explain the date. Police.
May it pleases your Lordship. Lordship, in this case, we have taken step on 19/5/2026 for respondent number 2, Lordship.
So Patiri, you are appealing for?
Respondent number 1.
Respondent number 1.
Question, TCR question.
Or Ms. Mazumdar, London Council for the appellant. The Patiri for the respondent number 1. Office note dated 21st of May 2026 indicates that service report in respect of respondent number 2 is still awaited. List the method after 2 weeks, everything service report of respondent number 2. After 2 weeks.
And PCR may be called.
The same
Remainder.
also indicates that the TCR has not yet. This is a urgent reminder to the learned party. For transmitting the record with the further delay.
Highly obliged, Lordship.
Obliged.
May I please, your Lordship? In this case, Lordship, as per office note dated service dated 8/5/2026, Lordship, the service of the respondent number 2 and 3 is awaited, Lordship. Postal track is Lordship.
Polita Eva for respondent number
1.
Respondent number. Third is Gorman Learned Council for the
1, 2,
applicant.
3, 9.
I is for
For delay, Lordship.
delay is yet to be confirmed.
Yes, Lordship.
And also our Mr. Polita for respondent number 1.
Yes.
I don't know.
In the office on dated 28/5/2026. And also seek the report of the postal track consent. Having conferred the same, learned counsel for the applicant is directed to take persistive upon respondent number 2 within a period of 2 working days from the date. Persistive upon respondent number 2 by speed post and also by legal process. Within 2 working days from the list of proceedings.
I'll take a copy of this petition from my understanding. Copy of
Mr. Polita submits that he is not been furnished with a copy of the interlocutory application and also the memo of application.
Yes.
Ms. Borman undertakes to furnish the same to Mr. Polita during the course of.
Obliged.
May I please, your Lordship? Lordship, we have taken step by speed post on 8/4/2026.
Third, Miss
P. Sharma.
Learned Counsel for the appellant. Office note dated 21st of May 2026 indicates that notice issued to the respondent number 124 still awaiting. This is the matter after 2 weeks awaiting service and put upon respondent number 124. After 2 weeks.
Item 34 by receiver.
May it please your lordship. Your lordship, here on last occasion, we had taken steps, and whether the steps have been served or not, it was been requested from the registry.
You are for the appellant.
And for the appellant, your lordship.
Heard Mr.
TL Oscar, your lordship, for DK, appearing for DK Agarwala, your lordship.
Pardon?
Appearing for DK Agarwala, your lordship.
Learned
TL
Counsel
Oscar appearing for.
Yeah, for Mr. D.K. Agrawal, Learned Counsel for the appellant. Office note dated 21st of May 2026 indicates that respondent number 1 is duly represented by Learned Counsel. Learned Counsel by filing his Ukalatnama. Then as such, a service upon respondent number 1 has already been completed. And the said office note also indicates that as per postal tracking report, notice upon respondent number 2 and 3 have been delivered, and a report has been placed at like A of the record. A result of the same indicates that notice upon respondent number 2 and 3 have been served, but the respondent number 2 and 3 remain unrepresented today. This is the matter after 2 weeks.
2 weeks, your lordship.
In the meantime, registrar shall issue urgent reminder to the learned court below for transmitting the record. Unless the matter after 2 weeks.
Deeply obliged, your lordship.
Item 35. May I please, my lord. My lord, in this case, my lord, defendant number 1 expired, my lord. Therefore, my lord, I filed one, my lord, substitution petition, my lord. And my lord, appellant side also filed one substitution application.
So this IA is for condonation of delay.
Condonation of delay, my lord, along with substitution petition. They also filed, my lord, one application.
477, there is no delay in your application. I number 477.
I number
477/26.
Okay. So this I is for condonation of delay in RFA.
No, my lord, in substitution application, my lord. But the application which, my lord, they filed, my lord, that number being, my lord,
The appeal
477.
has already been admitted.
Yes, your lord.
Appeal admitted.
Admitted.
Though it is a, my lord, RFA nomenclature, my lord, but the issue is totally different regarding, my lord, compensation to be granted due to, my lord, drawing of, my lord, national highway over the land of the, my lord, respondent, my lord. Therefore, my lord, judgment got, my lord, in our favor, my lord, they filed appeal.
Mr. Gogoi, you are for
Lordship, I am for respondent number 4, 7, 8, and 9, Lords.
I'm okay.
I'm getting it.
Copy lage need to substitution.
We have not served the IA copies.
Substitution মানে কম মার্ক হবে।
Four, 7, 8 and 9.
Lordship.
And Mr. Borwa for
Or 3 months.
respondent number 3. And in respect of rest of the respondent, 1, 2, and 5.
Yes, I am my lord for in my lord appeal 1 my lord Anil Kumar Kaur my lord. Now he is expired, therefore we have filed my lord substituted application. For application. 1A to my lord 1C my lord.
No, that's all right. First, we have to condone the delay.
But my lord, in their application, my lord, not there is no delay, my lord.
Pardon?
The application which they filed, my lord, appellant side, my lord, for substitution of my lord, I as a my lord, defendant number, respondent number 1, my lord. There is no delay. So, my lord, my 2 applications may be closed, my lord, and their application may be allowed, my lord.
Yes.
Application, my lord,
Difficult to understand. Yes.
my lord, for substitution,
So, then you are not pursuing this I number 464.
64, my lord. Because
So
not
we can
necessary.
close
sir.
this.
Yes, my lord. 63 and 64 both may be closed, my lord.
63 and 64.
Yes, my lord.
Heard Mr. Bormuya, learned counsel for the applicant in I number 463 and 464. And also heard Mr. Gogoi, learned counsel for the respondent number so and Mr. Borwa for respondent number 65. Mr. Bormuya submits that these 2 IA may be closed as he is not going to pursue the same. Accordingly, taking note of submission of Mr. Bormuya, these 2 IA being IA number 463 and 464 stands closed. Also, peruse the IA number 477 of 2025 filed by Mr.
R.A. Mazumdar.
filed by the applicant. Under order 22 rule for CPC for substitution of the name of opposite parties in place of respondent number 1 in the instant RFS. Who suffered demise on 5/6/2025. Mr. Mozumdar, learned counsel for the applicant, submits that there is no delay in filing this application and as such this may be allowed. Mr. Gogoi and Mr. Borua, learned counsel for the respondent number so and so submits that they have no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. The name of
Respondent number 1, your lordship. Anil Kumar Kaur. Page number 4.
the name of opposite parties number 1A, 1B, and 1C is substituted in place of the deceased respondent number 1, RFA number 3 of 2024. In view of the order passing the I, the learned counsel for the appellant shall file amended constated of the RFA number 3 of 2024 within a period of 1 week from today.
Yes.
List the matter after 2 weeks.
Diploma.
May I please, your lordship? Lordship, for substitution of petition,
For filing the substitution of petition, there is a delay of 859 days, Lordship.
Mr. Bhatt, you were appearing for?
I am appearing for the opposite party insurance company, Lordship.
Insurance company. Respondent number 2.
Insurance company is the appellant, Lordship.
Yeah.
In this case.
Lordship, case was disposed of, Lordship.
Lordship,
And after passing the judgment, Lordship, the claimant died.
That has been in an MSc appeal for orders, Your Lordship. Your Lordship, if convenient, it can be listed on 29th of this week. 29th.
Please mute yourself, Mr. Purkasto, I think.
With the consent of other side, I beg to
Mr. Jair Hussain, please mute yourself.
Lordship, after passing of the judgment on dated 26/9/22, claimant was died on 11/1/23. After 5 months, a letter was received by the legal heirs of the claimant on 26/5/23. After receiving of such letter, Lordship, legal heir of the deceased person written a letter to the registry of this High Court, Lordship, on 14/8/2024. Lordship, in my petition, delay petition, annexure 2, page number 10, Lordship, letter to the registry. After that, Lordship, Honorable Gauhati High Court passed an order that the said legal heirs are at liberty to make appropriate application before this court, Lordship. That order passed on, Lordship, 28/8/24.
In the MSc appeal number 33 of
33.
2015 has already been disposed of by this court.
Yes, Lordship. After that, claimant died.
Yes.
Then after died of the claimant, after 5 months, one letter was received by the legal heirs of the deceased from insurance company on 26/5/23. Letter was attached in Annexure 1 in my delay petition. Annexure 1 as a in page number 9, Lordship. Kindly page the Lordship.
Page number?
Page number 9 in delay petition.
So this is regarding furnishing of bank details.
Bank details. And after that, Lordship, legal heir of the deceased person written a letter to the registry of this High Court, and such receiving of the letter, Honorable High Court passed an order in page number 11, Lordship, on 28/8/24. And in this order, Lordship, Honorable High Court passed that said legal heirs are liberty to make appropriate application before this court. After that, Lordship, we have filed this substitute petition and with the delay petition, Lordship.
No, this matter can be disposed of by the learned member MSCT where you have filed the case.
But Lordship,
Lordship, in this case, after passing the judgment, the claimant
No,
died.
it's all right. Now no matter is pending before this court.
Lordship. So if they.
So the amount has to be deposited by the insurance company before the tribunal.
Yes, Lordship. But name of the legal heir may be, Lordship, On the record, Lordship.
By the original court or by the appellate court?
Lordship, in the judgment,
Lordship, kindly see the substitute petition 471/25/26. Kindly see the judgment in page number 9. Page number 14, para 13.
in the judgment, we are directed to deposit in the name of the claimant's account, not before the tribunal.
Not for the tribunal, Lordship.
Pardon?
In the judgment, we are directed to.
Page 14, para 13.
To give the payment in the name of the accounts of the claimant, Lordship, not before the tribunal, Lordship. That is why I asked to furnish the bank's detail, Lordship, and they informed that in the meantime the claimant died.
That's all right, but the MSc appeal has already been disposed of by this court. No matter is pending here.
And Lordship may give the direction to they may be appeared before the tribunal and to substitute the name of the legal heir. Accordingly, we will deposit the amount before in the name of the legal heir before the tribunal, Lordship.
Or she can obtain a succession certificate and place it before the insurance company, and insurance company on the
Not
basis of that succession certificate can deposit the amount.
Lordship.
What purpose will be served by substitution, this substitution petition, even it do not lie, because of the matter is already disposed of.
Lordship, unless and until a court order is passed, Lordship, we are not in a position to deposit the amount, Lordship.
No, that's all right. She can obtain succession certificate.
Lordship may give the direction accordingly, Lordship.
No, why should we give the direction? This I is not maintainable before this court. No matter is pending here. Appeal is a discourse of long back.
No.
How can we allow this substitution application after disposal of the appeal?
That is correct, Lordship.
Lordship,
Succession certificate will be issued by the court. That will be in order of the court. And on the basis of that succession certificate, you can release the amount. Where is the part? You see, we will list the matter day after tomorrow. You obtain necessary inspection. Heard, Mr.
Lordship, A.U. Ahmed, Lordship.
You Ahmed, learned counsel for the applicant, and Mr. Bhatt, learned counsel for the respondent, insurance company. List the matter day after.
Lordship, on Monday, Lordship. Fix the matter on Monday, Lordship. Monday.
Next Monday.
Next Monday. Of last week.
37.
Please, Your Lordship, my lord, this is a delay condonation application, my lord. While preferring the statutory first appeal, my lord, the delay has been occurred, my lord. So we filed an application, my lord. We have
How
extended.
many days?
So my lord is 463 days, my lord.
Yes, madam, you are for?
Yes, I am for the Lordship respondent number 2 and 3, Lordship.
Respondent number 23.
All official respond, my lord, is really matter relating to my lord acquisition, my lord. They have acquired, my lord, without paying compensation. The suit has been filed, my lord, and that was dismissed, my lord. So we prefer an appeal, my lord. Statutory appeal, my lord.
Lordship, but
The delay may be condoned, my lord.
there is some doubt, Lordship, in the prescription, Lordship, Annexer 1, Lordship, Annexer A, Lordship. Here, Lordship, the age of the Lordship, this is certified that Abdul, what, age is about 68 years, Lordship. On 19/2/2025. And he is having back ache and on. I'm sorry, pain bedridden. On the next day, there is another certificate, Lordship. Annexer, Lordship, 22/2025. Here, his age is 58 years. And here it is a advice take rest from 20 to 2025 to 25/6/2025.
That's his printing mistake, my lord. He is, my lord, 68, my lord. As on filing, my lord, he was 69, my lord. In the affidavit at page 11, my lord, it is there, my lord. And even in the suit also, my lord, we have seen, my lord, he is 60. His age is about, my lord, 69 as on the day of filing, my lord. But apparently, my lord, he is the person, my lord, he is leading this case, my lord. He was unwell, my lord, he is apparent, my lord.
One day difference, lordship, 10 years, lordship is get. And lordship, there is a
58, my lord,
it
typing
has
mistake
not
maybe, my lord.
properly explained, lordship, so far as the delay is concerned, lordship.
So, can we dispose of this application without hearing the other responses?
Yes, lordship, the other respondents is the
Other responses, my lord,
central government is
central
also there,
government is
lordship.
there, my lord. They appeared on last occasion, my lord. If your lordship peruse the last order, my lord, they turned up on the last occasion, my lord.
And revenue is also there. And
Yeah, let the delay be condoned. Really,
Yeah,
yeah,
my lord. Yes.
or lordship, but the central government council is also required, lordship.
But they entered appearance, but today none remain present in the court. What to do?
Yeah.
Okay, can
Delay,
you
my
inform?
lord.
After some time, the court master will inform the council. None appears for the applicant on call, lays the matter after 2 weeks. The event of subsequent non-representation of the applicant, appropriate order shall follow.
My lord, this is for delay of 280 days is filing the FAO. My lord, it was wrongly filed before the learned civil judge, my lord. And after it is detected that it is wrongly filed and it was returned.
So
And
how
to-
many days the matter was pending before the civil judge?
Civil judge, my lord, it was actually impugned order was 13/6/2025, my lord.
No, for how many days it was pending before the civil judge?
That was,
From which date to which date?
that is, my lord. That order is not searched, my lord. Actually, it was filed before the civil judge after impugned order dated 13/6/2025, and the last order passed in this case, my lord, is 17 to 2026, my lord.
17?
To 2026.
When it was filed?
Municipal 13/6/25 was filed before that. I am to search that order, my lord. The first order, I have not searched yet, my lord. The first order passed by the civil judge, my lord. That was not searched, my lord.
You say you are filing this application for condonation of delay of 280 days. You are claiming the benefit under section 14 of the limitation.
My lord.
But you have to demonstrate before this court from which date to which date the matter was pending before the court below.
That is, I will find my lord.
You will find
I will find it, my lord,
When?
because I am to search, my lord, 1 week, my lord.
1 week.
1 week, my lord. I will do search all the orders, my lord, from the.
Third, Mr. DCC Satyapukul, learned counsel for the applicant, and Mr. R. Sama for the respondent number.
Sole
Respondent. For the pair being made by Mr. Pukul, learned counsel for the applicant. 1 week time is granted to him so as to enable him to go through the record of the learned Court of Civil Judge, Senior Division,
Number 2,
number 2, Kamrup.
Kamrup, my lord. Kamrup M.
As to when the application was filed before that court. Parallel list the matter on. Thanks.
Obliged, my.
Item 40, by Mixi Mode.
May I please, your lordship?
Yes,
May I please, your lordship?
yes.
Lordship, this is an interlocutory application. The delays, my lord, is the 262 days, my lord. It is an appeal under section 30 of the Employee Compensation Act, my lordship. As your lordship knows, for filing section 30, there must be substantial question of law is involved, my lordship. As because there is a delay in 262 days, my lordship, the employee compensation passed an ex parte order and judgment, my lord, in the dated, my lordship, 24/06/2025. But the aforesaid judgment, my lord, it was not communicated. Even it was communicated, I have not got
No,
it, my
you
lord.
say
I am
there is
got
delay
after
of 200 and,
in the month of March last of this year, my lordship.
no, Mr. Council, you say there is delay of 261 days.
62 days, my lord.
Yes, first we have to condone the delay. We will issue
Yes, my
notice here.
lordship.
Or Mr. Your name, please?
Yes, my lord. Yes,
Learned counsel for the applicant.
my lord.
This interlocutory.
Aramin, my lordship.
Section 5 of the Limitation Act 1963 is preferred by the applicant. Kogan Ghosh, namely Kogan Ghosh, for condonation of delay of 261 days in preferring, especially in the first appeal under section 30 of the Employees Compensation Act 1923. To challenge the expertise judgment and order dated 24/6/2025, passed by the learned commissioner, Employees Compensation Borbeta, in EC case number 169 of 2024. Let notice be issued to the respondent, opposite party, stroke opposite party, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks.
Item 41.
Wait, please, one more sec.
Deeply
This is the regarding the condonation of delay. 172 days delay was caused in filing the MHC appeal.
Kakuria learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act 1963 is preferred by the applicant, namely Tinubala Das.
Yes.
For condonation of delay of 172 days in preferring connected MSC appeal against the judgment and order dated 22nd of August 2025, passed in MSC case number 146 of 2022 by the learned member, Motor Accident Claim Tribunal Borbeta. Let notice be issued to the respondent, stroke opposite parties, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List of 4 weeks.
Once of like.
Item 41, sorry, 42.
Non-appearance for the applicant on call is the matter after 2 weeks. In the event of subsequent non-representation of the applicant, appropriate order shall follow.
43.
My lord. There is a 64 days delay in preparing this appeal. So I will take step, Lord.
Or Mr. Bortman, learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act is prepared by the applicant. The National Insurance Company Limited for condonation of delay of 64 days in preparing appeal against the judgment and order dated 11/12/2025, passed by the learned member, Motor Accident Claim Tribunal Nalbari in MSC case number 92 of 2023. That notice be issued to the respondent opposite parties by speed post and also by usual process from today. List of third for weeks.
Lordship, obliged.
Item 44.
May please be me, Lord. Lordship, this is condolence of delay petition, first time Lordship, so notice may kindly be issued.
Mr. A.R. Agarwala, learned counsel for the applicant. Interlocutory application is prepared by the applicant. Namely, Ankur Jyoti Bora. For condonation of delay of 829 days. In preparing MSc appeal against the judgment and order dated 27/9/2023. Passed by the learned member, motor accident claim number 1, Kamarupan, Gauhati, in MSc case number 1014 of 2016. That notice be issued to the respondent opposite parties by speed post and also by usual process, returnable in 4 weeks. Within a week from today, list after 4 weeks.
Much obliged.
25.
My pleasure, Lordship. Here there is a 19 days delay, Lordship. Notice will go, Lordship.
Mr. Learned counsel for the applicant. This interlocutory application number 5 of the Limitation Act is prepared by the National Insurance Company Limited for conditional delay of 19 days in preparing. An appeal against the judgment and award.
9/7/26. 7/25, Lordship.
2025 passed by the learned member, auto accident claim tribunal welfare in MSc case number 316 of 2020. Let notice be issued to the respondents. Opposite parties returnable in 4 weeks. Step be taken by speed post and also by the process within a week from today and list of for weeks.
Obliged.
Item 59.
None appears for the applicant on call. For the appellant on call, list the matter after 2 weeks. In the event of subsequent non-representation of the appellant, appropriate order shall follow.
Item 60. 60.
Well, I have to take justice service, my lord, because sense of address of the respondent number, my lord, 2, we could not be able to take.
Mr. Ace Das, learned counsel for the petitioner.
Appellant.
Learned counsel for the appellant. Mr. Das submits that he may be allowed to effect service of notice upon the respondent by Dustin. Fair allowed after effecting service upon the respondent by Dustin. The appellant will file an affidavit to ratify before this court. Appellants. Upon the respondents.
1, 2, and 4.
Please, doctor.
1, 2, and 4.
1, 2, and 4. 1, 2, and 3. Please, doctor. 4 weeks.
Obliged.
Item 61.
My lord, this matter has been listed at the instance of the appellant also. They have
today.
Today, the appellant has made a mention for listing of the matter today also.
Lord,
I am for the response number 1 also.
Lordship may fix the matter for hearing.
Yes,
Lordship may kindly fix the matter for hearing.
hearing. Art Miss,
D. Hazarika.
learned counsel for the appellant, and Mr. Das for respondent number.
1 also.
Respondent number 1. The learned counsel for the appellant submits that this matter may be listed for hearing. Accordingly, taking note of the submission of learned counsel for the appellant, it is provided that recessal is the matter on communication. Oh, hearing.
Lordship, we may be furnished with a copy of the appeal memo appeal, Lordship.
You have not received.
No, Lordship, on the last occasion also I raised.
Sir, Dadas learned counsel for the respondent submits that he has not been furnished with a copy of the memo of appeal. Accordingly, learned counsel for the appellant is directed to furnish a copy of the same to Mr. Das within a period of 2 working days from today.
I'm obliged.
I have IA, my lord, 3401, my lord, for withdrawal of 50%, my lord. Appeal was of the year 2000, my lord. Long back, it was, my lord, appeal was admitted at interim stage, my lord. Kindly peruse also ISC, my lord, 3401, 24.
So
2007.
the amount has been deposited before the registry of this court.
My lord, that was not deposited because there was no such type of direction. Since the connected appeal has been admitted for hearing, the operation of the judgment order passed by the so shall remain state till disposal of the appeal. I understand. That is why I have filed this IA because it is a old case, my lord. Pending matter of the judgment was of the year 2017.
Lordship, before he further submitting, in this matter, engaged counsel, Ms. Didas Bormon. She lacks in another court, Lordship. Matter may be passed for further timing, Lordship, kindly. She lacks in court number 16, Lordship.
Okay, after some time.
May it please your lordship. As per office note dated 22/5/2026, as far as respondent number 1 is concerned, no response has been received yet. And regarding respondent number 3, fresh steps needs to be taken. Your lordship, for respondent number 4 to 7, we need to take instruction from client to furnish proper address.
Art miss.
A Navar.
Learned counsel for the appellant. Office note dated 22nd of May 2025. It's that no service report in respect of respondent number 1 to 7 has been accepted by the section. And the trial court record has also not yet been received. The said office note also indicates that issue to the respondent number 2 to 7 have returned answer to postal endorsement with the comment, with the endorsement, insufficient address for respondent number 2, 4 and 427. And addressee out of station in respect of respondent number 3. And no response has been received in respect of respondent number 1. The learned counsel for the appellant submits that she may be allowed some time to obtain instruction in respect of respondent number 2 and 427. 427. Pair allows to be taken by schedules and also by equal process within a response delay. List the matter after 4 weeks. Await service report in respect of respondent number 1.
Much obliged, your lordship.
65.
None appears for the appellant phone call, is the matter after 2 weeks. The event of subsequent non-representation of the appellant, appropriate orders will follow.
Please give me, Lordship, this is a prayer for withdrawal of the 50% award amount deposited by the insurance company, Lordship. Though it was order to deposit within 10 days, but they have delayed. Still, I pray for withdrawal of the amount.
Lordship, the appeal is on the ground that there is misrepresentation. The claimant himself caused the accident and evidence was adduced by the appellant company to that effect, Lordship. In the GD entry, he had that he was, first of all, he was the rider, not a pillion rider, and he dashed the vehicle from the backside. That was proved. And in their evidence also, we have taken the ground that their FIR, their evidence is totally contradictory, Lordship.
Lordship,
But
that was
the case is ready for, it can be fixed for hearing because the TCR has also come, Lordship.
PCR not received.
Received.
Lordship, the entire thing was discussed in the court below, Lordship. So we are now at the stage of 50% release of the only, Lordship. And they have contested the case in the court below.
Whether the amount is deposited.
Deposited.
Deposited, I pray for withdrawal of the same, Lordship.
Let him withdraw the amount subject to execution of one bond.
And if we win, they will return back.
Okay, no
Pardon?
problem.
If the appellant wins the
Yes,
appeal, they will
They-
return
they-
back.
they- they-
Therefore, the bond
Yes,
Yes.
they are obligatory.
are Mr. Agoral, learned counsel for the applicant, and also Hartness. Learned counsel for the respondent, opposite party. Interlocutory application is prepared by the applicant for allowing to withdraw a sum of rupees 9,77,100. 50% of the awarded amount deposited before this court. Before the registry of this court. Person to the order dated 28/7/2025.
Only one claimant, Lordship.
In MSC appeal number 3 of 2025. After hearing learned counsel for both the parties and also considering the facts and circumstances on the record, it is provided that the amount of 50% deposited before the registry of this court shall be released in favor of the applicant, subject to execution of one indemnity bond of equal amount. In terms of this, IA stands closed. Ms. Majumdar, learned counsel for the opposite party, however, submits that the appeal is ready for hearing.
No, Lordship will take up the appeal. Office note dated 21/1/26
That
says
should
no
come in the main appeal, Lordship.
notice.
Service is not complete, that should come in the main appeal, Lordship.
Okay.
Lordship, notice both ways was sent to respondent number. There are only two respondents, to respondent number 2. And after that, there is no office note. So Lordship may deem serve on respondent number 2 and office note dated 11/5/26, Lordship,
Today
LCR
only,
is.
Madam, only IA is listed today, not the appeal.
Appeal is there, Lordship.
Appeal to list, sir.
IA is on top.
Okay. Okay, then in appeal you note down. Heard. Ms. Majumdar, learned counsel for the appellant, and Mr. Arora, learned counsel for the respondent number 1.
First office note 21/1/26, Lordship. Notices.
Majumdar, referring to the office note dated 21/1/2026, submits that notice issued to the respondent number
To both ways. It was sent on that, by that office note. It can be deemed served, Lordship,
how?
because Lordship, it is
The
more
ID
than,
card has not been received.
Lordship,
AD card has not been received.
At that time, Lordship, it was, otherwise registry can give the postal track report. It is not speed post only, Lordship. Nowadays, AD is not there.
The problem is that after 1 month or 2 months, the data is not available in the website.
But Lordship, in this case, Lordship, our appeal is against the claimant only. There is no policy violation thing, no, nothing like that, or DL issue with the owner. That's why, Lordship, he can be taken as deemed served, Lordship, since it was.
Staff of can be there, Lordship, at the risk of the appellant, Lordship.
Then we will wait, Lordship. Since he got the money, that's why he wants that the case. I told him that as soon as they get the money, they keep the case to be dragged.
But that is the law, what?
No, it is not a question of law.
List the matter after 2 weeks, awaiting service report upon respondent number. Respondent number 2.
2.
Respondent number 2.
A registry
Office
can
note
give
dated,
a-
11/5/2026 indicates that LCR has already been received.
registry may, because both ways steps were taken, so registry may verify the as usual process also. Lordship. Track consignment as well as usual process. Report.
Registrar put up one up-to-date office note. After tracking the consignment in the departmental website. And also inquiring about service of notice upon respondent number 2 by usual list after 2 weeks.
Highly obliged, Lordship.
67.
Lordship, this matter has already been settled with the insurance company, and we have filed, both the parties have filed the affidavit in that respect also. Additional, earlier it was awarded with, but this is disability case, Lordship, 50% disability. So additional 6,50,000 they have settled, Lordship.
Where is the other party?
Well, Lordship. I'll call Lordship, then for the time being, Lordship.
Pending matters 25 and 26 by receipt note.
May I please, Lordship? May I please, Lordship?
Yes.
My lord, these matters, the state respondents are supposed to file their affidavit, my lord. Last occasion they have taken time. My learned friend has not filed yet.
Lordship, we may be granted some more time, your Lordship.
A date may be given, my lord, in on 17th June, my lord, if possible.
Or Mr. Prokestor, learned counsel for the petitioner, and Mr. Rampi for the state respondent. Mr. Rampi submits that she may be granted some more time to file the affidavit in opposition. Accordingly, taking note of the submission of learned counsel for both the parties, last opportunity is afforded to Mr. Rampi to file the affidavit in opposition. Then registrar list the matter on 17th of June.
Yes, Lordship.
It is being clarified that no further chance will be given to the learned counsel for the respondent to file the affidavit.
Obliged, Lordship.
Highly obliged. Highly obliged.
See, in this case, both parties agreed to settle the case at rupees 90 lakhs.
The matter was earlier referred to the local allot.
Local allot.
But the same could not be settled.
Yes, my lord. He is taking some time, my lord.
I have
Officer
paid for
is
the
there.
time, sir, and my lord, and after that, we have convinced our people also.
it will go to the HO, head office. So we have convinced our people, and even amicable settlement has happened for 90 lakh rupee between the parties and our company.
90 lakhs.
90
Earlier they are agree 80 lakh only, but.
Earlier we have offered 80 lakh only. Now it is came up 90 lakh.
Can a joint affidavit be filed?
Lordships earlier when this court clear order is there, Lok Adalat order is there, PROCEEDINGS order is there. Earlier order.
I can sign.
Samaj is.
That is there, but
Joint petition.
joint affidavit.
Okay, Lordship, we will file joint petition, Lordship.
Tomorrow or day after tomorrow, any day. Convenient to you.
Next Monday, it may come.
Next Monday.
Next Monday.
No, make it early.
Joint petition,
Mr.
you have
Bhatt,
to
you
sign,
go for
they
the
have to
appellant.
sign, party has to come.
You go for the appellant.
Yes.
Heard Mr. Bhatt, learned counsel for the appellant, and Mr.
Sharma. P. Sharma.
Sarma, learned counsel for the respondent. It is submitted at the bar that the matter has been amicably been settled between the parties, and both the parties agreed to settle the same at rupees 90 lakhs.
90 lakhs.
90 lakhs. Accordingly, it is provided that a joint affidavit shall be filed before this court, then Mr. Bhatt, learned counsel for the appellant, submits that the matter may be listed on next Monday,
Next Monday.
so as to enable the parties to file the joint affidavit. They are about to list the matter on Monday.
Is my.
Items for admission, item number 6.
They are supposed to obtain instruction regarding Lordship financial program. Is available.
My lord, it is under process, your lordship.
Process, that's all right, but when it is expected to complete the same?
Lordship, I won't be able to give a appropriate time, your lordship.
Then
So this is the instructions I have received, your lordship, today in morning, your lordship.
On the last day, 1 month time.
last order was passed on 24th of April.
Yes, your lordship.
More than 2 months elapsed. And still you cannot say when the process will be completed. You give me the exact time. Accordingly, you will fix the matter. After some time, you obtain instruction.
Yes, your lordship.
Next.
Standing item 37.
Sorry. Party to hire commandant 7 issue at the deputy inspector general UAG nothing for delay or donation. Delay or donation. It means to Kunia people. It is chukri where people see it.
Sir, perhaps you do not know
The matter
anything
lordship.
about the case.
Lordship.
Yes.
So let Ms. Bormon come. So Bormon or RKT Soto.
Lordship. She's on like semester matter in court number 16 matter.
No, I should.
I said.
Only CGC.
No, to me, my status হয়।
Kiba ase delay pandemic.
Delay to properly explain করা নাই।
My friend says that delay was not properly explained.
That was my submission.
That I will say. This was not.
Otherwise, one is a statutory appeal, first appeal, my lord. 96, my lord, CPC. So lordship has to hard, my lord, but only the part is that only delays there in the delay part has to be.
Lordship, let it become next week. I take the instructions on that, Lordship. If something is there, because delay continuation, I just now I got it, Lordship. Next week, Lordship. It will be without limit. My friend will give me a memo. Okay.
Mr. G. Alam.
G. Alam.
Learned counsel for the applicant. Ms. Borman for the respondent number, opposite party number.
2 and 3.
2 and 3, and Mr. Roy for respondent number, opposite party number.
Lordship, 5 and 6, Lordship.
5 and 6.
Yes.
Mr. Roy submits that he is being engaged today and he may be granted some time to obtain inspection. They are allowed, list the matter on Monday.
Lordship. One extra, Lordship. My name may be reflected in the cause list.
Shall reflect the name of Mr. Roy.
Lordship.
That cause list.
Mother on 1st of June, my lord.
1st of June.
Obliged, man.
Oh. 62, I am for the appeal and lordship. 62, wait.
Once my parts are about the time, Masida is on legs, Lordship.
Pardon?
Time being, Lordship. Masida Mr. is thus is on legs, in court number 3, Lordship.
So this is for condonation of delay.
Yes, lordship, for cross objection, lordship. That initially I have filed lordship, MSc appeal lordship.
Lordship, IA 3401 is for 50% withdrawal, Lordship.
Okay. Okay.
50% on the, but there is a no order. Say, Lord,
Order of
for
stay is there, but
deposit of 50%, there is a no order, lordship. So that application is lordship, in fact, so there is a no lordship.
Lordship, let my senior.
As there is a no order, lordship, for
depositing the amount.
yes, lordship. So, lord.
Okay, let
Yes,
let senior come.
Item 7.
Mr. Soma, you are for respondent.
I am for the sole respondent, my lord.
The appellant is absent today.
My lord.
None appears for the appellant on call. Mr. Sarma, learned counsel for the respondent present. List the matter after 1 week in the event of subsequent non-representation of the appellant. That would be noticed. Follow.
Date may be fixed, my lord. Date may be fixed, my lord.
On field to.
Keeps it deeply applied.
And for the respondent number 1.
Sir, I am receiving for the appeal and lordship.
For the appellant.
Yes, lordship.
So service completed in this matter.
No. Yes, lordship, you are first, respondent number 1. He is appearing for respondent number 1. Lordship, so for respondent number 2 and
Service not completed.
service is not complete, I think, Lordship, for respondent number 2.
Or Ms. Bormon, learned counsel for the appellant, and Ms. Third,
Yes, Kathak Lordship.
learned counsel for the respondent number,
One, respondent number one.
respondent number 1. Office note dated 2/4/2026 indicates that no step has been taken by the appellant.
No, we have already taken steps, Lordship.
When? There is office note dated 2/4/2026.
Yes, Lordship. On Lordship, last of, we have taken steps, Lordship. I will verify, Lordship, whether we have verified the record. Lordship.
Okay.
Yes, Lordship.
Office note dated 2/4/2026 indicates that no state or notice has been taken
Yes.
by the appellant hearing. Ms. Borman submits that she will verify the same. Steps taken.
Taken, Lordship. Yes, I have taken. Yes, yes, by speed post.
24th April. April. However, Ms. Borman submits that she has already taken step on 20th/4/2026. Accordingly, it is provided that rest shall put up one up to date office note after verifying the postal track consignment report. Please the matter after 1 week.
Apply.
Back to the lordship. Lord, this appeal has been already admitted, my lord. This has been complete upon respondent number 2, 3, 4, and 5 already appeared. 6 is also appeared, my lord. My lord, may fix it for hearing.
Service
And,
completed.
Yes, my lord.
Or Mr. Day, learned counsel for the appellant. And
But
Mr.
one more.
I'm for all, of course. I'm for
also
1
learned
to 5.
counsel for the
Just one more.
respondent number. 1 to 5.
Yes, madam.
And Mr. Gogoi for
I am
respondent
for
number
6.
6.
6, Lord.
6. It is submitted at the bar that service in this matter has been completed. Record receipt.
Record, I think, my lord, is already there.
And
Receipt.
the TCR has already been received and the matter may be listed for hearing.
There is an
Accordingly, it
IA, my
provided
lord.
that-
I have not been given the copy of the IA. There is an IA.
My lord, one small submission before I start, my lord. On the, I'll add, probably it was, we'll give the copy, my lord. The copy of IA, my lord, if it is not given, we will make sure that it has been given to my lord, my colleague. My lord, the payment in this case of the reference case, because this is a land acquisition matter, my lord. So with regard to the compensation amount, my lord, it has already been deposited with the DC Kamrup, my lord. Only the remaining amount under section 28, my lord, that is probably some amount is pending. So that fact may be recorded, my lord, that I am on instruction submitting that the reference case, the principal amount has already been deposited. Only the interest part with under section 28 is pending to be deposited. That they may apply and get that amount. Order, my lord, will, the reference case order, my lord, will find in page number, my lord, 63, my lord, the operative part of the order. If my lord permits, I will just read that order, my lord.
No, not necessary.
So this, my lord, on a calculation given by the DC Kamrup, the amount has already been transferred to the DC Kamrup. As per the page number 63 order, the amount has already been transferred.
Thereafter, my lord, as because the section 28 interest was not granted, a review was filed, and that interest part, my lord, it is yet not been deposited, but what I was been told, they have been trying. So if the claimant wishes, they may withdraw the amount which has been lying with the DC Kamrup, my lord.
So if the dispute is only with regards to the interest part, then this review petition expressly stated that they have no objection to the determination of the quantum of either in interest or the total quantum. Or your lordship may kindly.
No, the appeal is already admitted for hearing.
Yes, my lord, appeal is already admitted for hearing.
So this IA is for staying the.
My lord, IA we had filed for to stay the proceedings, my lord, which the order of review, my lord. Now, because we were of the belief that an execution case would be filing, they would be filing an execution case to execute the order. So in that presumption, we had filed an IA. That we are seeking a stay of the review petition, that order of review, where that 28% interest was imposed upon us, and we have been directed to pay. There was other directions also. Basically, the IA was for the stay only, my lord, to put it precisely. Now, as because there was no execution case filed.
Stay of the review petition.
Stay of the order, my lord. Let me put it in this way. Stay of the order, the judgment and order which was been passed in this case.
It would be stay of the payment.
My lord, so we were seeking a stay of the order, my lord. But as because there was no execution case been preferred by the claimants, we have not pressed that IA. IA is lying, but we have not pressed it. So that is, my lord, the last order of Justice also records.
Okay, since they have not filed any execution petition, there is no urgency in.
So that is the reason I am not pressing the IA, my lord, as of now. I am not pressing the IA as of now. The IA is there, my lord. I have not pressed. But the copy, if my lord colleague requires, he will give him the copy, my lord. No problem.
Of the IA.
Of the IA, we will give him the copy. If it is not been given to him.
Yes, I haven't
for the
received the copy.
applicant and Mr. O. Loskar for the respondent. Respondent number 1 to
1 to 5.
1 to 5. Mr. Gogoi for 6. 6. Mr. Loskar submits that he has not been furnished with a copy of this interlocutory application. However, Mr. Day, learned counsel for the applicant, undertakes to furnish a copy of the IA to Mr. Loskar during the course of the day.
My lord, please.
This is at least this matter along with LA appeal number 1 of 2026 after accepted.
24 June. My lord, please. My lord, we'll just record this fact that we have, because I am under instruction to put before this fact to the court, my lord, that the amount of the principal amount has already been deposited with the DC Kamrup, my lord.
Now we are not concerned with the
My lord, please. But I am just placing this fact because I have been asked, my lord, by the claimant, because claimant wanted to withdraw that amount, that they may do so with the DC Kamrup, my lord. That is the only.
No, we cannot compel them to withdraw.
No, that is only my submission. Is only this, my lord. We are not asking for compelling.
Withdraw it.
I'm just submitting, my lord, that it is up to their choice, my lord. Oblige.
May I please your lordship? This is an appeal under section 37 of Arbitration and Conciliation Act against the interim during pendency of this without deciding fact filed under application 34 of Arbitration and Conciliation Act. Interim measure is issued. However, its order itself it says the record LCR has not come up. My here only submission is this one, my lord, very short, simple, because little bit fact says this one. This land and building was acquired by National Highway Authority under provision of National NH Act 1956. They have been paid their compensation as per decision of assessment made by competent authority land acquisition. They are not being aggrieved. They have accepted, but not aggrieved by being aggrieved by this assessment. Under the provision of section 3G5 of NH Act 1956, they have approached to the arbitrator. Arbitrator has enhanced their amount. 73 lakh something. That being agree, they are not satisfied with that amount. Then they have to, if not satisfied, they have to go to that is district judge. But nowadays it will just senior division as per new commercial act. Now he has approached before the Learned Civil Judge Senior Division under provision of section 34. As your lordship aware, section 34 is clearly makes application for set aside. That to be set as, or now here only a latest judgment also says either you have to set aside or allowed. That is to be decided first. Now my respondent is claiming that during pendency of that application under section 34, they want that award which is passed by learned arbitrator, but it is under challenge. That is, if it is allowed, my lord, that is just like it is final order. Because that amount has been challenge, 73 lakh something amount is not, they are not happy with that amount. They want more money. That is why this, according to them, it is to be 73 is to be set aside, not enhanced. And moreover, if at all it is there, Mr. This, then also learned under section 34, they cannot enhance. Single judge, district judge cannot enhance, either to set aside or allowed. Then they can remand back or they can decide for this. Issue again is to be decided by. That is my submission is there, sir. As a record is being called for. Record is being called for. It's awaiting there. Judge order itself is without record is not received. Now, very likely to be shortly this record will come. Entire matter may be heard. Otherwise, today my prayer is this. Stay for that amount which has been given, then it has to be stayed. Otherwise, the proceeding may go on. But if it is being paid, then it will be difficult for us also. What manner it will be considered? Suppose it is allowed, then if it is allowed, then it will be reassessed again. That is our issue, my lord, here. And my humble submission before lordship today, this as this case is in final stage, let get everything is finished up. Finality, then we'll pay. But otherwise, the dependency is difficult because it is amongst the final order. They want not that some amount, that is whatever amount is given by, awarded by learned arbitrator, that amount they want. But on the other hand, it has been challenged before the learned district judge, now presently learned civil judge senior division in Kamru, now. This is my submission, my lord. Here my submission is there, may be admitted, and even like either during this till get finality, because already it is in final stage, only LCR is waiting. As soon as LCR is final hearing there, till that that particular amount which has been given, maybe stayed.
Yes.
Let them say.
My lord, my land was acquired by the National Highway Authority. I was the claimant as per the National Highway Authority Act. I have to appear before the arbitrator. The land acquisition officer is the arbitrator. I appeared before them and the award was amount sanctioned in my favor. So I was not satisfied with the amount. I went for under section 34. My lord, under the Arbitration Act, my lord, section 36 is there. I can file an application. They have not gone against that award before the learned civil court, setting aside that. They have not gone. They have accepted that award. My lord, I want an enhancement. I have went there and I have filed an application. My lord, now they have come under section 37. The first submission that I want to make before your lordship, with all humility, it is at all not maintainable. If your lordship just look into, my lord, 36 and 37, your lordship. 37, my lord. First of all, if your lordship, I take your lordship to section 36 of the Arbitration Act. where the, may I read it slowly, my lord? Where the time for making an application to set aside the arbitral award under section 34 has expired, then subject to the provisions of subsection 2, such award shall be enforced in accordance with the provision of the Code of Civil Procedure in the same manner as it will a decree of the court. So their time for going against 34 is over. They have not gone. I have filed an application for enhancement along with that under the provision of CPC for an application to release my award amount. Now, my lord, I will take your lordship to 37. It starts with a non-obstantive clause, my lord. May I read it slowly. Notwithstanding anything contained in any other law, for the time being in force, an appeal shall lie from the following orders and from no other. To the court authorized by law to hear appeals from original decree of the court passing the orders, namely, refusing to refer the parties to arbitration under section 8. It is not. Granting or refusing to grant any measures under section 9. It is not. Setting aside or refusing to set aside an arbitral award under section 34. It is not. So how could he come under 37? If that against that order, he should have come under 227. 37 is not at all applicable. And moreover, my lord, the order that has been passed against the impugn order, which my friend has come before your lordship, my lord, that is at page, your lordship may just look into that page 79. They have not gone for 34. I have gone for enhancement. And this is the impugn order against which they have come. Page 79. That both the parties are represented. The date is fixed for today for passing on order on petition filed by the petitioner, praying to release the awarded amount from the respondent. The warrant from the petitioner submitted that the petitioner was a patadar of an area of land measuring 3 hectares, 3 bighas, 4 katas covered by such and such under Nis Sindur Gurupa and such, Kamrup, Assam, on which cold storage facility under the name and style of Chitra Cold Storage was started by the petitioner in the year 2000. The petitioner submitted the petition has obtained loan from various banks and financial institutions for.
Okay, Mr.
And my lord, last submission.
The petition filed by you was allowed.
Allowed.
You are allowed to withdraw the amount.
My lord, they have to pay me the amount.
No,
And-
you are allowed to withdraw the amount.
And the submission is at the last part is of the order is, my lord, at
Page 82.
82.
Yes.
The code.
They'll release the compensation amount of rupees 73 lakhs.
This was awarded to me
27,000
by the
rupees
arbitrator. This was awarded to me by the arbitrator.
So according to you, this 37 petition does not lie against this order.
And moreover, my lord, the Constitution bench recent judgment 4:1 has decided from the part severability can be done and can be given. This is multi-impressive.
Pardon?
My lord, severability, the concept of severability, because that part, which is part, because they have not challenged. So in any circumstances, this amount which has been directed to be released cannot be taken away because they have not challenged under section 34. I have only challenged it for enhancement. So in any circumstances, they cannot withdraw that money. They have not challenged this award. The award is in my favor. I have only filed for enhancement for modification. This is, my lord, discussing all other judgments, my lord. The recent 4:1, the Constitution bench has dealt with this, my lord. Para 82.
Para?
My lord, I'm giving this para page 85. Para 85. Para 85. Because this is Justice 4 judges has consented this judgment, and my lord, and the another one is descending the next part. Accordingly, the conclusions. Para 85. Your lordship has got it. Para 85.
Para 85, yes.
Para 85. Conclusions.
So, para 85.
85 conclusion. Well, the first part, because
Yes, conclusion.
accordingly, the questions law referred by such and such and answered the stating the court has a limited power under section 34 and 37 of the Act to modify the arbitral award. The limited power may be exercised under the following circumstances. when the award is severable by severing the invalid portion from the valid portion of the award as held by part 2 of our analysis. So it can be severed, but the balance amount which will be enhanced. If it is dismissed, is gone. If it is allowed, they will pay it, and the amount which has already been awarded, they have not gone for 34. That has to be paid to me. That this concept has been decided, and ultimately this has come to a conclusion. And the next is descending part. Next portions are then ultimately the single judge Malad has dissenting the fact, that is Justice K.B. Vishwanathan. He has dissenting, and this is 4 judges in para 85 has allowed this. This part can be severable, and the learned trial court has also decided this, Malad. Learned trial court page 80, your lordship may look into of the impugned judgment. Page 80 of the impugned judgment, my lord, last but one paragraph. May I read it, my lord? The learned counsel for the respondent, it is them, my lord. On the contrary, submitted the doctrine of severability has to be applied to the facts of the case. The learned counsel has submitted the petitioner has challenged the very award which has been passed by the sole arbitrator. Hence, seeking release of enhanced compensation amount in such circumstances is contradictory and ought to be rejected. This concept itself has been decided by this constitution bench. The severability part can be done because they have not challenged the 34. This amount in any way circumstances they cannot take away from me. They have to pay me this amount. From the wrong concept, they have to take it out. And how is it, my lord, they have come under 37? Because under 36, I have filed an application for release of the amount. If they have to come against that award order, they have to come under 227. 37 in any circumstances is not maintainable.
We have probably heard the views. Mr. Borua, how it is maintainable under?
No, it is a maintainable, my lord. I'll satisfy your lordship. First and foremost thing, clearly I'll go. He's first and learned friendly insisting on section 36. When 36 is enforceability. But they have if it is that award or arbitrator is not being complied by me, definitely. But they themselves have challenged. That is, matter is pending before the same award is being challenged. It is not separate award. That is under that. Second point, now under what provision of this day during pendency of application under section 34 of Arbitration and Conciliation Act, now they have filed one application, simple one petition filed. That is 224, 225. That I may be allowed. Under what provision may be allowed? First, let him quote. He is coming before it. Then I'll show your lordship. Then I'll show you what provision I'm coming. Because even time being your lordship, see 37 to B. 37 to B. If it is stated that their application as an interim application, no provision is not mentioned, then I have to come, I have to suppose any case, they have to quote their number under what provision he is there entitled. The law doesn't say anything. Author of the this act doesn't say anywhere that during pendency of due file edition. They have not said. Either they have to take on 9 or they have to take under 17. 17 means that they have to take, and time being it is assumed that it is under, though they have not mentioned about that application which is pending, before the only simple one application is pending. Okay, during pendency of this one, I may be paid 73 lakhs rupees, something, whatever. That itself, my lord, that itself is I do agree today that if this fails, I have to pay. Yes, I have not come. I intend, why I will come?
No,
I'm agreeing.
You filed the application for enhancement.
That's correct, my lord.
Yes.
Enhancement, but their word is this to set aside first, not only this one. Lordship may peruse. They are when can be enhanced, my lord? Even Supreme Court judgment. That Supreme Court judgment, my learned Francis Gauhati, Balaswamy case,
Gauhati has been referred.
Now that is a Gattiwala Swami case
No,
here.
no.
But anyhow, whatever is suspension, if suppose my lord, as per Supreme Court judgment, learned civil judge either to set aside or allow. He cannot enhance. This amount is to be, if it is either 73, he himself is claiming to be set aside first. Our application is section 34, what is time being allowed to be permission, I may be allowed to read. Application for setting aside, section 34 clearly says, my lord. 34, section 34, application for setting aside. This clearly says that a recourse to a court against the arbitral award may be made by only application for setting aside and award accordance with the decision. Here, my lord, clearly saying this setting aside, section 34 clearly said setting aside. Then until unless being set aside, until unless, my lord, under section 34 we set aside that judgment, whatever award is being first to set aside. If suppose I am filing application under section 34, your law that learned district judge are not considering my, that will go up. It is allowed. My application of filing set aside means, if allowed means that allow means that award is set aside. If not allowed, that will remain. But they cannot modify. It is a question of enhancement. Enhancement, the issue is, that is only issue, my lord, here before lordship. That will be, law point is to be decided here.
Mr. Borua,
My lord.
you please go through this decision.
The decision I have got. I have decision, my lord. I have
Gayatri
decision.
Balasamy.
I have Gayatri, that is lordship Gayatri.
Yes.
I have. I wanted to give a lordship.
This is
This is
constitutional
enter-
bench, my lord, not
That is-
earlier judgment. It has been referred. And the
Gayatri
questions has been. on the
No, it
same
is
thing.
Gayatri.
Gayatri has been referred to constitution
No.
bench.
Anyhow, let me give, I'll go through, let me see. Because
Okay, we'll give you one date.
Monday.
Uh,
Monday ki dekhe? Monday session? May, na? Today? Huh? Okay. Oh, yes, my lord.
Monday.
Monday I'll be
Okay.
available because
Learned
28 I'll be
Mr.
not
Borua,
available.
Learned counsel for the appellant. Mr. Roy Sotori, learned senior counsel assisted by Mr. Yes. Learned counsel for the respondent. This appeal under section 37 of the Arbitration and Prohibition Act 1996 is directed against the order dated 12/8/2026 was to the learned civil senior division in this arbitration execution case number 1 of
अरे देश तेरे delay की जाए अरे number to day अरे हेतु के तो day लिखिल हो तो जीवन में उड़े
It is to be noted here that by
GS
the order dated 12/3/2026, the learned civil judge senior division Kamrup Amingao has granted interim order during the pendency of the application arbitration execution case number 1 of 2025 to release an amount of rupees 73,27,009 rupees to the respondent. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugn order dated 12/3/2026.
Operator mindly हो सकता है
Mr. Roy Sotori, learned counsel for the respondent, however, referring to the section 37 of the Arbitration and Conciliation Act and also a decision of the Constitutional Bench of the Supreme Court in the case of Gayatri Balasamy versus MS ISG Novas of Technologies Limited in civil appeal number 2025 arising out of SLP, which will make it C number 15336-15337 of 2021. Submits that this appeal is not at all maintainable. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that let's establish the matter on next Monday for hearing on the point of maintainability of this petition.
All right. Highly obliged.
Yeah. Lordship, here I have received the verbal instructions to take for 1 month.
1 month.
1 month, the Lordship.
Part. Mr. M. Khan, learned counsel for the petitioner. Ms. Dharam P. learned standing counsel for the respondent in secondary education department. Ms. Dharam P. on instructions submits that 1 month time may be granted to complete the process of compliance of the for finalizing the compliance report before this court. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that rest shall list the matter on after 1 month.
Obliged.
My lord, MSC Appeal 306/23, my lord. Your lordship take up this matter. I filed, my lord. Because, my lord, in that case, my lord, ex parte, it was, my lord, portion of the impute judgment and order was, award was stayed, my lord, on 27/9/23.
No, is there any direction for depositing 50% of the awarded amount?
No, my lord.
No.
That is why, my lord, I have prayed for, my lord, something, my lord, to get, my lord, because it was accident death case, my lord, murder claim for some amount, my lord, 4,20,000 rupees, 50% it will be, my lord. That is why, my lord, she has filed this case. It was of the year 2014.
Yes.
Since then, my lord, matter is pending, my lord, from the year 23 also, my lord. 3 years already here, my lord, before this honorable court also.
No, can we finally hear and
Yes, my
dispose
lord,
of the
then
matter?
also, my lord, it will be better. Your lordship may fix a date, my lord. Otherwise case, I have also filed one cross appeal, my lord. So
Okay.
many parts.
Mr. Ace does learned counsel for the applicant and Ms. Borman learned
I am for the appellant, Lordship.
Ms. Borman for the appellant.
Yes.
No, order is being passed in the IA.
Yes.
Learned counsel for the applicant and Ms. Borman for the opposite party. This interlocutory application is preferred for depositing 50% of the awarded amount of rupees 4,20,000. 20,000. Sir Das submits that while staying the impugned order, judgment and award, in MSC appeal number 306.
Yes, my lord.
306 of 2023. No order was passed for depositing 50% of the awarded amount, and as such, this interlocutory application is being preferred by the applicant for depositing for directing the opposite party to deposit 50% of the awarded amount. However, it appears that the MSC appeal number 306 of 2023 and the cross appeal number 461 of 2023 are ready for hearing. LCR received copy?
23.
And the LCR has also been received. And in that view of the matter, this court is of the view that instead of passing any order in this interlocutory application, the entire matter would be heard on next day. And the same may be given final consideration. Accordingly, it is provided that rest is list the matter on except.
June. Obliged, my lord.
Yeah, please be, my lord. Lordship, the other side is busy in other court, so 1 week time. Lordship. It may be fixed on 2nd June if possible, Lordship.
On the hearing made by Mr. Agarwala, learned counsel for the applicant. Rest is the list the matter on 2nd of June.
2nd June. Much.
Mr. Agarwala, the appeal is yet to be admitted. Appeal is not yet admitted.
Not yet registered even, Lordship. In the delay condolence petition itself will settle the matter. Delay stage only.
No, in that case, you can go to the tribunal. File the application there.
No, Lordship.
Here, the appeal is not yet admitted. Why should we pass such an order without admitting the appeal?
Appeal may can be registered and admitted.
No. Without condoning the delay. That
Lordship,
cannot be.
since both
Whether
sides-
you withdraw this appeal and the interlocutory application, you go to the trial court,
Lordship, they've
to
settled
the
here.
tribunal and file the application there.
No, Lordship, we have come for the enhancement, so they've settled there.
No,
Let's
no.
try on the 2nd June, Lordship.
We'll see that. First, we have to condone the delay.
Yes.
Thereafter, we have to admit the appeal. Only then we may consider this
Okay,
application.
Lordship.
Otherwise, not.
Then 2nd June we will do the needful, Lordship.
May please your lordship. The records have already been received. Lordship may kindly fix the matter for hearing.
Now we are yet to receive our extra copies.
We'll give it here, yes.
Third, Miss,
U. Bihani,
learned counsel for the
appellant.
learned counsel appearing on behalf of
D. Rathi, lordship.
D. Rathi, learned counsel for the appellant, then Mr. Pegu for the Pegu, learned CDC for the respondent. The learned counsel for the appellant submits that LCR has already been received and the matter is ready for hearing. Accordingly, it is provided that recess will list the matter after 2 weeks
Much
for
obliged.
hearing. Mr. Pegu learned CGC submits that he has not been furnished with a copy of the memo of appeal. The learned counsel for the appellant is accordingly directed to furnish a copy of the memo of appeal to Mr. Pegu within 2 working days from today. List after 2 weeks.
Lords, similar order may be passed in item number 13.
Item number
13.
13.
Yes, lordship.
Here also, Lordship, no extra copies were provided, Lordship.
Okay, here, Mr. Roy. Same order. Memo of appeal shall be furnished to Mr. Roy within 2 working days from today.
Much obliged.
Item 14. Item 14 by VC vote.
Item 14, made.
Item 14 by.
Made, please, your lordship.
Yes.
The appellant is being the claimant in MSC case number 36, 2024, injury case. The appellant is highly aggrieved by passing a judgment dated 28/11/2025 by the MSC Tribunal, Sunitpur, in case number 3624. The appellant prefers the appeal for enhancement of the compensation awarded amount.
Okay. Heard, Mr. Your name, please?
M. Islam.
M. Islam, learned counsel for the appellant. This appeal under section 173 of the MB Act 1988 is directed against the judgment and award dated 28/11/2025 passed by the learned member MSCT Sonitpur in MSC case number 36 of 2024. Which in bracket injury filed under section 166 of the MB Act 1988 as amended in 2019. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and award dated 28/11/2025. Admit, issue notice to the respondents, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Shall call for the record from the learned tribunal. List the matter after 4 weeks.
Item 50.
Obliged.
Wait, please, your lordship. I mean, item number 15, lordship.
Yes.
My video has been disabled, lordship. So, lordship,
Yes. Yes.
Item 15. Mr. Jefferson, please respond.
yes, lordship.
Yes.
Lordship, this is an statutory appeal under section 173, lordship, against the judgment and order passed by the learned MSCT Dorang Mongolde, lordship, in MSc injury case number 136 of 2019. And herein the appellant has filed this appeal for enhancement of the awarded amount, lordship. So the notice may go, lordship.
Okay. Heard Mr. Zaid Hussain, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and order dated 21/2/2026 passed by the learned member Motor Accident Claim Tribunal Dorong Mongoldo in MSC. I case number 136 of 2017-19. Filed under section 166 of the MB Act. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the interim judgment and award dated 21/2/2026. Admit, issue notice to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. Rest is a call for
Deeply
the
obliged,
record of the learned tribunal.
Deeply obliged, lordship.
16.
May I please? There is a statutory appeal by the insurance company against the judgment and award dated 6/2/2026 passed by the learned MSCT Dhubri in MSC case number 92 of 2017. Basically, we have taken the ground of that victim was the gaseous passenger and driver of the vehicle did not have any license. So appeal will be admitted at this stage. Call for the LC.
Mr. Hazarika, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 6/2/2026 passed by the learned member Motor Accident Claim Tribunal Bhuburi in MSC case number 93 of 2017. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the interim judgment and award dated 6/2/2026. Admit, issue notice to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Rest is a call for the record from the learned tribunal. This is the matter after 4 weeks.
There is an IM for stay of the.
You have to deposit 50% of the
lord.
awarded amount.
I'll deposit.
Heard, Mr. Hazarika, learned counsel for the applicant. This interlocutory application is prepared by the applicant, Serum General Insurance Company Limited, for suspension of the operation of the impugned judgment and award dated 6/2/2026 passed by the learned member Motor Accident Claim Tribunal Dhuburi in MSC case number 93 of 2017. Mr. Hazarika, learned counsel for the applicant, submits that connected appeal has already been admitted by this court and the record has already been called for from the learned tribunal, and as such, there is a requirement of staying the operation of the impugned judgment and award dated 6/2/2026. Peruse the application, then the documents placed on record, and also peruse the impugned judgment and award dated 6/2/2026. Since the appeal has already been admitted and the record has also been called for, these parties of the view that the impugned judgment and award dated so and so passed by the learned member motor accident claims tribunal Dhubri in MSC case number 93 of 2017 may be stated. Accordingly, the impugned judgment and award dated 6/2/2026 passed by the learned member motor accident claims tribunal Dhubri in MSC case number so and so stands state till disposal of the appeal, subject however to depositing of 50% of the awarded amount before the registry of this court within a period of 2 months from today. In terms of our base, IA stands disposal.
Oblige.
पूर्ण सो गया।
In another bench items, relevant matter for judgment. Item 1, WPC 4 of 23.
Rate petition allowed.
Item 2, WPC 39 of 2025.
Oblige, madam. Apa yang mesti lah? Mana?
Rate petition dismissed.
Division bench matter.
Clear na? I can look more. I can know. I mean, double panel. नहीं दो चीज बने एक अलाउड है एक अलाउड है डिसमिस हो रहा है तो ये कैसा कर हो रहा है
All the rate appeals stands dismissed.
वही ऑब्लाइज डिसमिस नहीं होगा डिसमिस के लिए